he's collecting rent from this guy and then giving rent to this guy. So the tenant in a sublease situation, the original tenant stays involved, may or may not get the property back at the end of the sublease, that depends on the term. But for the whole term of the sublease stays involved and takes rent and pays rent, over or under. That's a sublease. Okay. There's a different situation called that's what they define as with the tenant retaining a reversionary interest. That's what I thought was a bit confusing. That's only if the term is different here. If this lease were going to end at the same time as that lease, there wouldn't be any reversionary interest in the tenant. The land would revert right back to the landlord at the end, of course. The term's over. They're both out. Okay.
But it'll still be a sublease? Will it still be a sublease?
If this lease is run out, this lease is definitely over. Because there's no more possessory right in either one of these guys. When you enter into this, you would never have a 3-year lease here and enter into a 4-year sublease.
Right, but the book seems to suggest that only when has this reversionary interest, then it's an actual sublease.
I'm sorry, the book suggests what? No, I didn't.
Only if there is a reversionary interest, then it's an actual sublease versus an assignment. Is that?
Well, no. What they're saying is no. There will be a reversionary interest in the tenant. Theoretically, if they ended on the same day, within a minute of each other, theoretically, the right to possession would revert to this guy, but it would then instantly revert to this guy.
Okay.
What they're trying to get, and that's why I said that whole reversionary concept, I was trying to explain what they meant, but frankly, I think it's bull. It's simply, the tenant still stays here in the middle. This lease is still alive between these two guys, and this lease is alive between these two guys.
Okay.
And that's really the importance of it. That whole reversionary concept is really, yes ma'am.
If a tenant has an option to renew, but they've subleased it out, and the tenant has the option for a 3% rent increase, but rent's got up 5%, can they then, take their option to renew and then just sublease it out again?
Sure, absolutely. No reason why not. Yeah. And sometimes, no, if you would, if this is even within this 3-year lease, after 2 months, this guy might do a 1-year sublease to this guy, and then this guy moves out, then do a 6-month sublease to another guy. The point is, all of this has to take place within this term, because then it's all over. When this term is over, this guy has no further right to be subleasing to anybody. It's over. Okay, any others? Yes, sir.
You know that company, I think Regis, they're like executive office spaces and things like that?
I don't know of them, but
But what they kind of do is they act as a tenant in an office space, and then I guess they lease out smaller office spaces to another tenant. So they kind of act as the primary tenant, and then they sublease it out. Okay.
yeah, that's true.
And then they work on a spread between the subleases and collecting what they're really paying back to the landlord.
There are concepts in lots of places called master leases too, which is a similar concept, where the owner of a piece of commercial property will master lease the whole thing to this guy. And then to all the world, it looks like he's leasing out to everybody, but all these are subleases.
Right.
Because the master lease was the real prime lease, was the original lease, and all these are subleases. But unless these guys who are ultimately leasing it out go and check the public records and see who the owner is, as far as they know, this guy owns the thing.
Right.
They think they're dealing with the owner.
Is there an obligation to inform the landlord about the sublease?
Say that again?
Is there an obligation to inform the landlord about the sublease?
Well, that's a whole interesting separate concept that we'll talk about in a second.
Okay.
Whether the lease prohibits you doing this. And some leases do and some leases don't. If there is no prohibition, there is no obligation to get consent, and there is no obligation to inform him whatsoever. Now, assignment is much simpler. All we're doing in an assignment is taking this guy out of the picture completely. This guy moves over here and takes the remaining term of the lease. The person that we called the sublessee before is actually known as the assignee. Assignee. A-S-S-I-G-N-E-E. And what happens is the tenant assigns his lease. That's why it's called an assignment. An assignment is a transfer. The tenant assigns his lease to the assignee. The assignee steps into the shoes of the tenant and for all intents and purposes becomes the tenant for the balance of the term of the lease. In that case, the assignee, who's now the tenant, pays his rent directly to the landlord. It's a third-party situation where we brought in somebody new, but the original tenant gets out. We still have, and that's why they're talking about it as a third party. They're not three people anymore, but it was a third party who came in, took an assignment of this lease from the old tenant, in fact became the tenant, and it's on the same terms. Takes over the lease on the existing terms that the tenant had. Yes, sir?
Doesn't the landlord have to like go through a new approval process for that?
Yes, yes. Again, always yes, because leases always say that you can't do this without landlord's consent. But absent a provision that says that you need the landlord's consent, the landlord does not have any right to say anything. So I don't think you'll ever find a professionally drawn lease, commercial or residential, either one, that doesn't say subleasing and assignment are prohibited without the landlord's consent. Sometimes it says not to be unreasonably withheld, sometimes it doesn't. Courts different states have different standards about what tests they'll let a landlord impose. Particularly in that situation where the sublease was at a higher figure, hell, the landlord would love to turn that down. I'd rather get it back and lease it to that guy at the higher rate. You know, that means values have gone up, the rent was too low. The landlord wouldn't want to do that. There's a differential there, and the landlord would sure rather be getting it than have his tenant get it. So landlords don't like these things. Realize what's happening here is the landlord has picked out his tenant and decided who he wanted to rent the property to. Now that tenant's going out and picking out somebody else and the landlord has nothing to say about it. So landlords are not happy at all about having this happen because it's not their doing. But there are some situations in which it might be a good thing for a landlord. If the tenant was about to go under, and was going to shut down and move out, well, maybe it's a good idea for the landlord to permit this. Keeps it going, keeps the rent going. It can be good, but what sticks in a landlord's craw is the fact that they no longer have decided who's in possession of their property. And that's why they want rights of approval. And then when they have rights of approval, courts require them to be reasonable. But then we get back into the same stuff like a condominium association approving a purchaser. You know, what's reasonable, what's fair, how do we decide what his economic ability to perform is, what does he know about the restaurant business? What if you want to assign to somebody who always wanted to have a restaurant but I've never had one before? Well, there's a good chance he's going to fail. So a landlord might not want that guy in there. But absent a provision, the landlord has nothing to say about this. But I guarantee you in any written lease there's going to be a provision. It's going to prohibit it without at least the landlord's consent. And sometimes, absolutely, period, no, none of that stuff under any circumstances, don't even ask. Okay, that's two examples, as the materials talked about, of a third-party transaction. What happens when a third party comes into play, whether it was the subtenant or whether it was the assignee. But now, we've got the concept about what happens over here. What happens if the landlord sells the land to a third party? You got a new buyer over here that owns the property. What happens to the lease? Anybody?
We'll have to redraft them.
I'm sorry?
We'll have to redraft the leases.
Not necessarily.
No, it holds until the
Lease
end of
is
it.
in effect. Lease remains in effect. Absolutely. If after a year the landlord sells the property, this lease is still in effect. This tenant pays the new buyer. The lease remains in effect. The property is said is subject to the lease for the term. So the landlord cannot sell the property and thereby kill the term. Any more than the tenant, by selling their right of possession, can't kill the lease either. Try to bring somebody else in, but the lease is still in effect for 3 years. Likewise, if the landlord sells the property to somebody else, the lease is still in effect the remainder of the 3 years. Okay, so those are transactions with outside parties, outside the landlord and tenant. What effect does it have on the lease? Basically, in both cases, the lease, on either side, the lease is staying in effect. Yes, sir?
They can buy out the lease, right?
I'm sorry, I couldn't hear.
He can buy out the lease from the tenant?
Oh, sure, you can always work out a deal with the tenant. Yeah, if the new buyer didn't like the lease and wanted to write the tenant a check and say, would you go away? Of course you can. Understood. You bet. Okay, there's one other set of interesting circumstances that we've touched on before, that is the question of, as to third parties, what happens when somebody gets hurt on the property? Who's going to be liable, the landlord or the tenant?
Everybody.
You're right. That's what the trial lawyer is going to do. He's going to put them both in a room, he's going to sue them both, and say, I don't really care. I have damages, who's going to pay me? There's a whole area of the law. It's torts. We've talked a little bit about torts. Torts are a civil wrong that you can sue somebody for damages. There is lots of case law going both directions, and a lot of it has to do with the terms of the lease in terms of whose obligation was it to maintain the property. And that's who the injured party has his best shot against. Generally, the law says that the person who has control and possession of the premises is the one who owes the civil duty to the third parties to maintain them in a safe condition. But we have that other general area of the law we talked about where the landlord has to comply with building codes and safety codes. So what's going to happen is the injured party's lawyer is going to sue them both. And they're both going to do this. And they're each going to call on their insurance companies. And they're going to fight it out over who defaulted in the duty to make the premises safe so that the third party didn't get hurt. And this is the slip on a banana peel in the shopping mall thing. Was it inside the door of the Apple store, in which maybe it was the Apple store, or was it outside in the mall, which maybe it's the landlord? And what if it's right in between? And who put the banana peel there? And whose obligation was it to send somebody around to pick it up? This is what trial lawyers do. And I can't give you any definitive rules other than the court decides whose obligation was it to make that area safe, and therefore whose fault was it that somebody got hurt, and therefore that's who should pay, and that's whose insurance company should pay, and that's why you have liability insurance, whether you're the landlord or the tenant, either one. So when somebody gets hurt, who's going to pay? Know, if you would, that landlords always try to put in the lease an exculpatory clause, where the landlord says, no matter what, whoever gets hurt here, not me, it's the tenant. Two things. Number one, that term in the lease is not binding on the guy that got injured. He didn't sign the damn lease and say he'd only look to the tenant. That's what the lease says. Only the tenant should be responsible in case anybody gets hurt. And the tenant says, okay, I agree, and signs the lease. But the guy who got injured didn't say that. And that's why he's not bound by that allocation of liability between the landlord and the tenant according to the lease. But secondly, the courts believe that those exculpatory clauses are against public policy. And they hate them, and they don't want to enforce them. And the courts are there to make sure that aggrieved injured people get paid for the damages. And they don't like one guy saying, even though it's my fault, you're paying for it. So, there's going to be a clause like that in every lease. And it's very unlikely that the court is going to give it any effect because it violates public policy. And number two, excuse me, number two, it's not binding on the tenant anyway. The tenant didn't sign that and agree to it. I'm not sorry, not binding on the injured party.
Right.
Yeah, the tenant did sign and agree to it, but that doesn't bind the rights of the guy who got hurt. Okay. That's the end of landlord and tenant. I'd like to do, I think, a break, is that what somebody said?
No, I said release.
Well, yeah, we're gonna talk about the lease, but what I'm thinking about is maybe that perhaps in order to make sure that we get through it, because I want to at least get this far, I want to do chapter 9 first. And then we're going to come back and go through the lease. Because we can go through the lease as fast, as quickly, or as shortly as we need to get us out of here at 4:30. But I am adamant that we're going to get through chapter 9 today, and I don't want to get stuck in the lease and not get that far. What that of course means is we're not going to get through chapters 12 and 13 today. To my great regret, we're just not moving as fast as I'd like us to be. That's my fault. And we're definitely not going to make 12 and 13. I want to go through chapter 9 now. I'm going to keep going too. If anybody needs a break, just go. But I don't want to stop because I want to get this done. So I'm going to shift to chapter 9 on easements, which I think is real important. It's not related to leases, but then we'll come back and we'll do a lease and make sure we get out. Chapter 9 is easements. Easements are hugely important. Easements are the right to use somebody else's property for a limited purpose. And what's most important is they're irrevocable. This is a permanent right, like a deed. And in fact, you're going to see that they're created by deeds. So this is forever the right to use somebody else's property for a limited purpose. And as you're going to see in a minute, it's probably, but not necessarily, the guy next door, the neighboring property. Because that's whose property you're most likely to use. But there are two types of easements. And the first one is exactly that. It's the neighbor's property. But what we're saying here is, it's the right of a parcel of land, not so much a person. It's a right of a parcel of land and its owner to use another piece of property. And that's almost always going to be the adjoining property. That's an easement, a pertinent. And the word appurtenant, of course, as I know you know, means it goes with, it travels together with, and And what we're saying is, it travels together with the ownership of a certain piece of land. That's what has the right to use the neighbor's property. The other one we'll talk about later is an easement in gross, and that has nothing to do with the ownership of a piece of property. But this is a parcel's right to use another parcel.
So in simplest terms, are we
I'm
talking
sorry?
about sidewalks? In simplest terms, what are we talking about?
I'm going to tell you. In the overall simplest terms, we're going to talk about access because that's the biggest one. The right to use somebody else's property to get to yours.
Okay.
And maybe that's the best example to use. And let me, if I can, dummy up another drawing and get this thing to go. We've got two pieces of property. And one of them's on the road here. And this one's not. It's the right to use this, it's the right of this piece of property to travel over this piece of property to get to the road. Usually, there'll be a roadway like along one boundary. That's usually what you're going to have. Usually it's for a road. Now the concept that we're going to talk about, and I think the best way to understand the concept is using access. And access simply means, as I know you all know it means, how do I get to something? How do I get to it? Were it not for this easement here, theoretically, the only way you could get to this piece of property would be by helicopter. Or maybe by an easement over this guy's land, or maybe an easement over this guy's land to get to the road back here. But what we're talking about
Or
is
paper toll.
a landlocked piece of property that you got no way to get to it. And access is huge. And if this is the only public dedicated road and this is the only way in and out of here, this parcel has no access to a public road. And if you have no access, your property is totally unmarketable. Nobody is going to buy your property if they have no way to get to it. It's just that simple. So, there are a lot of other concepts intertwined in this, but hopefully that's enough of an example that we can relate back to tie it all together and make it make sense.
Does that happen?
I'm sorry?
Is there property like that?
It probably was.
Is what I'm
Is
saying?
there property like that?
Is there property like that? Sure there is. What if I owned that whole thing and I sold off the back half? There you go.
They
I owned the whole thing and I sold off the back half.
They wouldn't AG require?
Who would require? If the guy who's buying it is smart, he makes me give him an easement, but we're gonna get to that. But absent that, he's got a landlocked parcel. That's what we're talking about, access. Now, we're all used to public roads and we think they're all public roads going everywhere. You buy 40 acres out near the Everglades, there is not necessarily a public road. And even if there is, and you sell the back half of it, there's no way to get to it. And that's what we're talking about, access. Now, easements are for lots of other things, as you'll see. They're for utilities. But I think the best example to tie together the basic concepts we're talking about would be access and a road. We said an easement appurtenant is an easement in favor of a parcel of land. This is an easement appurtenant because it's in favor of this parcel of land. This is called the dominant estate. This is the parcel that benefits from the easement. This is called the servient estate. This is the parcel that serves, that is burdened by the easement. Its dominant parcel gets to use the easement. Servient parcel, this guy still owns this. We're not saying he deeded this strip to this guy. This guy gave this guy an easement to use the south 10 feet. Not to own it, but to use it. The right to use somebody else's property for a limited purpose. The reason this is called an easement appurtenant is because this easement doesn't just benefit a person. It benefits a piece of property. And you're going to see that's important later when we talk about when you transfer title to pieces of property. Basically, this easement is appurtenant to this parcel. It belongs to this parcel. And whoever is the owner of this parcel, or whoever his visitors are, anybody connected with this parcel, even if it's deeded and deeded and deeded, gets the benefit of this easement. Because we said they're permanent, they're irrevocable. And places that aren't in cities and out in the farms and stuff like that, man, they live by this stuff. And if you don't have it, you don't have any way to get to the back 40. Okay, we've got a dominant estate and a servient estate. And the important thing I think we talked about already. The dominant estate, the easement travels with the title to this estate. Anytime this is deeded, the dominant estate's title basically owns this easement, whether it's mentioned or not. If you take a deed from this guy, and even if your deed does not mention the easement, but it should, it carries with it this easement. What that means is, this guy doesn't get to say, ha-ha, you sold it, the easement's over. It's on there, it's irrevocable, it belongs to the ownership of this parcel. And of course, when this guy sells, it's still subject to the easement. Remains subject to the easement forever. Yes, sir?
So it's not always mentioned on the deed?
I'm sorry?
It's not always mentioned on the deed?
It is not always mentioned on the deed, but it should definitely be mentioned in the deed. I'm not saying don't do it. I'm saying you can't separate it. You couldn't, here's what happened. This guy could cancel the easement if he wanted to. But he couldn't sell this parcel, leave town, and keep the easement, and he still owns it. That's what I'm saying to you. It's not separable. It may not be separated from the ownership of this parcel. So that if I sell this piece, I can't keep this. Or if I sell this piece, I can't convey this easement to this guy over here. It belongs to this parcel of land, and that's why we're saying it's not personal. We're going to talk about personal easements in a minute. They're a totally different animal. This is an easement appurtenant, and what it means is it belongs to this parcel, really. It belongs to the ownership of that parcel. It's always tied to it. Not to the people, but tied to the parcel of land. And if this guy ever sells, it's still on there. And if this guy sells, it goes with it. And when he leaves, the seller can't take it with him. It's staying with that parcel forever.
How do you then verify, like, for instance, I was looking at a piece of property that had, you know, the only access was through someone else's property.
You're examining title of this piece of property, right?
Right, so if you're saying it's not always on the deed, how do you then verify? Do I have to go by the servient estate's owner?
You have to go by the first, here's what I'm saying to you. Once it's been created properly, and we're going to talk about that in a minute, how it gets created. If you're looking 3 or 4 deeds down the road from there, it doesn't matter that it's been mentioned in each one of those deeds. It's forever from the time it was created, right. So you're going to search the title all the way back to here. If you search the title all the way back and you never find it, not good.
Okay.
Okay? We're gonna get into what are some of those things too in a minute. But the important thing is that once it's properly created, it belongs to this parcel forever. And when this is deeded, it should be mentioned. But if it isn't mentioned, that doesn't make it go away, is what I'm saying.
Okay.
Okay, it belongs to it, any number of conveyances down the road, even if not mentioned. Okay, now, that's an easement appurtenant, that's an easement for the benefit of a piece of property, which benefits that piece of it. There's one special little kind of easement appurtenant that I want to tell you about, just because you may not have run into them before, and it's called a party wall. A party wall is two pieces of property. Here's the dividing line. Two different owners. They decide, let's build the buildings and we'll share this wall that's right down the middle, right on the property line. We'll share it. I'll build my building over here. You may build your building here, and you may build yours even taller. But the concept is, together, we are sharing this party wall. Now, this guy owns his half of the party wall. And he has an easement on this guy's property for the other half of the party wall. And vice versa. Now, there's usually a party wall agreement. And a party wall agreement is entered into by only two parcel owners. When we get into more people sharing walls and stuff like that, then we're getting into a PUD or a condo or a co-op, where we all share all these damn walls, all kinds of different ways. But when two property owners share a wall, a common wall on their dividing line, that's called a party wall. And you see these things up north everywhere. When you look at row houses, or what's the word for brick houses and
Brownstones.
and stuff?
Brownstones.
Yeah, they're all like this. And it'll be a solid wall, it'll be a firewall. Fire codes require that these be block walls. This is not gonna be framed. But the point is, as owner of this parcel, I have an easement appurtenant to my parcel over this guy's property for this portion of the wall. And he has an easement on my property for this portion of the wall. And these are easements appurtenant. This easement belongs to this parcel, not to the owner of this parcel, but it belongs to this parcel, and vice versa. And what a party wall agreement does is say, hey, we're gonna share this wall, and neither one of us is gonna tear it down. And if it somehow gets knocked down, we agree to share the cost of putting it back up. But we both agree that this wall is imperative and we gotta have it, because without it, both of our buildings are coming down. So don't mess with the party wall. But its legal concept is based on easements. Is that my right to have a wall up on your property is based on an easement, and his right to have a wall up on my property is based upon an easement on my property.
Right.
That's a type of easement appurtenant. And that's it, that's a party wall. Okay, now, the other kind of easements are easements in gross. What that means is, there is no dominant estate. There is a servient estate, and here's an example. A utility easement along the front 10 feet of this property. For sewer lines, for power lines, for electric lines. It's an easement. It's not in favor of a specific piece of property. it's in favor of FPL, City of Fort Lauderdale, whoever installs utilities. But the point is, it's not because they're next door. It's not tied to a certain piece of property either. It's a right, we talked about an easement as a right to use somebody else's property, but this is the right of an individual, or usually a company, to use somebody else's property, but not tied to a specific piece of property. So there is no dominant estate that the easement benefits. But there is a servient estate. It's the parcel that has the easement on it. It's the parcel that serves. It's the parcel that's subject to the easement. So an easement in gross has a servient estate that's bound by it and serves it, but it's not in favor of a particular piece of property. It's in favor of anybody. Utilities. Utilities, I think, are the very best example. But it's a personal type easement, and I think the book has 3 or 4 other little pictures of other ways. I've forgotten what else they are, but to me, utilities are the best example.
I didn't really understand the picking fruit one.
I'm sorry?
I didn't understand the picking fruit example of easement and gross.
The what example?
Picking fruit, where you're allowed to pick
Picking
fruit off
fruit?
the person's property.
You have an easement to walk on my property and pick my fruit. Yeah, you're gonna see there's another section at the end of this. It's something
The profit one?
called a profit appendage or something. I think that's where it was. Yeah, it is. That's at the end of the chapter.
Yeah.
I crossed that out as another one of these, not responsible, but it's one of those things. That's a specific one where you give, it's a type of easement to let somebody remove part of your soil or your produce. So theoretically, the right to use somebody else's property, an easement to come onto my land to pick my fruit. It's me giving you a right to use my property.
But if it's fenced off,
Sorry?
if it's fenced off, you don't have that right.
No, you have to give it. Someone has to give it to
You
you.
have to grant it. We're gonna talk in a
has
minute
to be
about how
done.
you grant these.
That's what I thought.
Okay, here's how you create easements. This is another weirdo in the book. They call it creating an easement by expression. To me, a much better term is by intentional action. Creating an easement because you meant to do it, and you did it in a document. Since they call them an express grant and an express reservation, maybe that's where they get expression. This is the intentionally creating an easement by a written document. And there are 2 ways you do it. And let's use our example. Let's say the easements didn't exist. And somehow we ended up being neighbors here. And this guy came to me and said, geez, I'd sure like to be able to use your south 10 feet to get out to the road. And I said, sure. So I grant him an easement. It's an express grant. It's a deed, an easement deed. I give a deed to him that says, I hereby grant to you an easement over my south 10 feet for the purpose of getting out to the public road. That's how you create it. That's an express grant. It's a deed. It's an easement created by grant. Okay? Or by reservation. That's the other way. It's still by a written document, but the fact scenario gets flipped. I own this whole thing, and I decide to sell the front. I'm going to keep the back. In my deed of the front to this guy, I reserve unto myself an easement over the south 10 feet for access to highway. So, this guy can either grant an easement to this guy, or this guy can sell, keeping this and reserving this easement. Now, where that would show up would not be in the chain of title on this property. It would show up in the chain of title on this property because it was a deed of this property. So when I owned the whole thing, there were no easements at all. I own all this land and I got frontage on the highway, hell, I don't need an easement. But when you start breaking it up, we need to either grant an easement to this guy to get to the highway, or we need to reserve an easement over this property to get to the highway in favor of that property. But the reservation would show up in the chain of title on this one. The grant would show up in the chain of title on both of them because it affects the title of both. So you either grant an easement or you reserve an easement. And they're calling it by expression. I call it by intentional act. Yes, sir.
If you're granted an easement, the person who's granted an easement, do they file that in the clerk's office? How did it become record?
You just file, it's a recordable document, just like a deed.
Okay.
Yeah, it's an easement deed.
Oh, right.
These things are called, sometimes called rights of way. Right of way is the same thing. You hear about the street, the city's right of way out there? Somebody, at some point, in one of the ways that we'll talk about in a minute, by a document or by eminent domain, somebody in a document created a right of way in favor of the city for that street. And that's an easement. Now, if they convey title to the city, that's something different. Title is not an easement. If you actually deed the south 10 feet to this guy, then this guy owns this. This line doesn't even exist anymore, okay? He's got an L-shaped parcel. If you deeded him the 10 feet, this guy no longer owns it at all. There is no easement. This guy owns this L-shaped thing. But if two different people own them, and this right is across this owner's land, that's what makes it an easement. Okay. But they're created by a deed, the same as if you deeded the 10 feet. But you talk about it in there, I hereby grant or I hereby reserve an easement over the south 10 feet for the purpose of getting to the road. Yes, sir.
What happens if the owner in the front won't give you the easement?
What does what?
What happens if you can't get an easement from anybody in the surrounding area?
Why would you buy the land?
We're going to talk about what the courts will do in that situation. But you don't ever want to be in that situation. You make sure, if you're buying this, you make damn sure you got a way out of it. That's the point. The things that we're talking about that the courts are going to do to bail you out is if you've done something stupid and you bought a piece of property and you haven't figured out I better have a way to go with it. That's why I told you that access is something huge that you look for every piece of property. Anytime you look at a piece of property, you need to say, how am I going to get in and out of here? Now, if you're on Highway 441, pretty easy. But if you're set back a ways, and you're buying from the guy who has all the frontage on 441, and you're back kind of in the middle of a block, and your parcel isn't going to face on any of those side streets and then going to face on 441, then you've got to think about how am I going to get there? And the fact that land is platted does not necessarily help. Platted lands have lots on them, but they don't necessarily all front on the road either. So it's just like looking at all the other attributes of a piece of property, but in a real estate lawyer's mind, this is right up on top. How am I going to get in and out of there? A title insurance policy guarantees you that you have access. Doesn't create access for you. But the point is, if you bought that as landlocked and you had a title insurance policy, you're protected because the title policy, the title underwriter's job is to get you an access. And the underwriter's going to have to go to that guy with a frontage and buy you an easement. because that's something that title insurance insures, that your piece of property is not landlocked and that you have access to it. And access does not mean, again, by helicopter, it means access over roads to get there. Not necessarily publicly dedicated roads, but legal right to get there, which means it is.
As the property owner in the front, wouldn't it be more beneficial for state tax assessments to physically deed that and liability to deed that strip to the guy, literally?
Could be. Might be the guy in the front has we have minimum parcel size restrictions. It might be that he owns, that entire parcel is 20,000 square feet, and that the city rules say you may not build on any parcel less than 10,000 square feet.
Okay.
So by deeding that piece to the guy in the back, he might only have 9,500 square feet, in which case he wouldn't be able to build at all.
Okay.
There are reasons to retain it.
Okay.
Yeah,
Yes.
but in terms of the liability, remember that the dominant tenant has to maintain the easement, so if anything happens to him, that's kind of his own fault, right? Because he has to maintain it. So if it needs to be paved or trees cleared or whatever, that's on him.
So as a property owner, I don't have to maintain my property, which is the easement to the other guy?
If you would not have to maintain the
The
servient owner,
Mhm.
which is who you're calling the property owner.
Yeah.
But he's really the servient owner.
Mhm.
He does not have to maintain the easement property for the purpose for which the easement exists.
Okay.
If it was for roadway, he wouldn't have to pay it, no. The guy in the back who's using it as a road. Now, doesn't mean that he can't use it too. He may have his driveway come out of here and go out the same way too. But as far as between the two of them, the one who has the benefit of it gets to use it, the one who has to maintain it.
Okay.
Okay.
Did I explain that? Good.
Now, what we talked about was how you expressly create an easement. By a grant or by a reservation. There's now a whole huge area of the law about what if you didn't do that? And how does the law try to take care of you and protect you and give you access to your property? If in fact you haven't done something about it yourself. And these are called implied easements. The first group they called easements by expression, which I call intentional, granted, do it. And then these are implied easements, and these are easements that exist basically in common law and that the courts will help you out with. But remember, in all these cases we're talking about, we're about to talk about all the things that the courts may do for you to give you an easement if you don't otherwise have one. Remember, that's not a fun way to get an easement. It's expensive and time-consuming, and you're not going to recover your attorney's fees. And win, lose, or draw, you're going to pay your lawyer for that lawsuit to go in there and get you an easement that maybe you forgot to get when you bought it. Or your title examiner forgot to get for you when you bought it, or forgot to tell you before you bought it. Yes, sir?
Or it could be like inherited from your parents or something that didn't have an easement, right? That could be another situation.
The appearance that there's an easement?
No,
Inheritance.
air property. If it's air property, like in the country or rural section,
Uh-huh.
and you never knew it had an easement, so I'm thinking of a situation, and it's locked in, is that another way?
Well, what we're saying is, anytime you buy a piece of property, you need to research, how am I going to get there? If you don't see a recorded easement somewhere, or a publicly dedicated road to your property that fronts on your property, you need to start thinking about, before I buy it, what am I going to do about that? And is there a way that I can negotiate a grant of an easement as part of my purchase? And maybe not buy it if I can't negotiate one. Because what you don't want to do is end up in that situation where you bought it and you're falling back on, oh my God, I don't have any way to get in and out of here. Let me try to hire a lawyer to help me out and see if he can get me away. Remember also that if your title examiner, whether it's a title company or a lawyer, is doing his job, when he examines the title before you have closed, is going to say to you, what about access? I don't see any sign of access here. How are you going to get in and out of there? And then you go research it some more, but you try to resolve the situation before you've closed. What we're going to talk about now is, but you didn't resolve that situation before you closed. You didn't find a recorded easement or a dedicated street. What am I going to do now? Okay? All right. These are implied easements. The first ones were express easements. These are implied. Now, the first one they talk about is an easement implied from prior use. I'm not sure how I feel about that one. That one is a concept of, wow, there was a barn back here, and this guy always used this road to haul hay in and out of the barn. So when I bought the barn from him, gee, I probably should have gotten an easement anyway because he used to use it as a road going to the barn. It's a little weak, but it might get you somewhere. What you need to understand is, when I told you there's a lot of expense to go into court and proving up an easement, courts do not like landlocked parcels. Courts believe that every parcel of land should have some way to get in and out of there. But remember that if you go to court, not only do you have those costs, but the courts aren't necessarily going to give you exactly the road you were looking for. They're just going to try to find you a way to get in and out of there. The courts may say in this situation, yeah, I know you'd rather have this, but we think if you go 7 miles down this road down here, maybe this will get you in and out of here too. So you may not get what you want from the court. The court may find you, by implication, as an implied easement, a way to get in and out of there, but it may not be the best one that you'd like to have, and it may not be the one that you would have negotiated had you thought about it before you bought this thing. So there's one implied by prior use. I always use this to get stuff in and out of the barn, so it probably ought to be an easement now that I own the barn. Maybe. Maybe you can convince the judge of that. Maybe the judge will give you the way out the back that you don't like. Implied from necessity. This is basically the concept that we just talked about. That the courts are going to give you an easement of necessity or a right-of-way of necessity to some way or another get to your parcel of property. The courts don't like a landlocked property. So they're going to find something for you. But like we said, it may not be a good one. And it may not be the one that's the shortest or the easiest or that you wish you had. There are easements implied from plats and maps. Best example of this is like a map of a campground. Say there's a map that shows 20 campsites and maybe some dirt roads going through there to go through all the different campsites. And the guy who owned the land decided to start selling off these campsites. So he sells off campsite number 7 and campsite number 12. And then somebody realizes, oh my God, there's no road back to number 12 or number 7. The courts say, if you are shown a map as a part of a sale that reflects a road, you're entitled to an easement over that road. But it may not be a dedicated road. It may mean, what I'm saying to you is a dedicated road is a road that is dedicated to the government in some form or another, the state DOT, the city, the county, somebody. And the big importance of the dedicated road is, if a road is dedicated to the public, everybody gets to use it, number one, which is nice. But number two, the governmental entity will maintain the road. In all these other cases we're talking to you about where it's not dedicated, where they're private roads, well, private roads are maintained by private people. And then you get into a fight over who ought to maintain it. What happens if it gets washed out? Who's gonna pay to repair it? Is the guy who's gonna pay to repair it the guy whose land, the part that happened to be on that got washed out? Or is it gonna be the 7 other guys down the road who are dependent on that road? But it's washed out on his parcel. If it's dedicated to the public, you know who's gonna take care of it. You get on the phone, you call the city and come in here, repave this damn thing, and they'll do it. Because it's dedicated to the public, it's a public road. But if it's a private road, you're into all of these spats over who's gonna maintain it, and when and how, and who's gonna pay for it. But if you bought a piece where you don't have a recorded easement, and you were shown a map that reflected some roads, the court will protect you and give you the right to use those roads. That doesn't make it a public road, that doesn't make it maintainable by the government, but it'll ensure your right to use it. Now, in governmental regulation that we'll get into in a later chapter, and y'all have a whole separate course on governmental regulation of property that's taught by Professor Tracy. Help me? Yes, thank you. I'm sure you talked there about platting, and we're going to talk a little bit about platting later in our governmental development thing. But platting is when you record with the government a subdivision map. And it lays out all the different lots. And it also lays out the roads. And it, by the mere filing of it, dedicates those roads to the public. So, of course, if the roads are created, what we're saying here, if the roads are created by a recorded plat, you have the right to use it, just like everybody else in the public. It doesn't take an express grant or an express reservation to you alone to have the right to use your road. It may arise by dedication on a plat. Yes?
So you said that if, because I'm looking at a property where, you know, there's, it's fronting, there's one house and it's fronting one street, and there's no road to the back lots. But it's already platted. That road is you're saying is already dedicated to the city, or is that going to remain a private road?
No. If the platted lot is shown on the map,
Right,
with some sort of a roadway to get out,
right.
then it's dedicated on the plat. It becomes a dedicated road when you file
To the
the plat.
city?
To the city or the county or the state
Okay.
or whatever, yes.
Okay.
If it's shown on there.
Yeah.
If it's not shown on there, basically you bought a landlocked parcel. You may have dedicated roads all around you, but
Right.
no way to get to you in the middle. And that's when we start getting into all these other things about, Your Honor, help me out, get me a way out of here.
Right.
With an implied easement somewhere. All right, now there's one other concept here of implied easements. And this is like something that was teed up a minute ago about adverse possession. There's also the concept of an implied easement created by prescription. And prescription is going ahead and using it even though you'd never had the right to it. This is you're a trespasser. But the concept of the law is, if you trespass often enough, and if you are notorious and adverse and open and flaunting it in the face of the owner, you know I'm doing this, and he doesn't do anything about it, that creates an easement.
That sounds like a girlfriend.
That's called an easement by prescription.
Seriously?
What did you call it? I'm sorry?
Sounds like a girlfriend, man.
Find these people.
All right.
Where does he find these people?
From the island.
Oh, really?
Taking a hole.
Okay.
Keep working on it.
Now, one more concept on prescription, and this is the chapter getting off into funky stuff. But it's talking about easements for light and air by prescription. And this is what right does this parcel of land have to getting light from over top of that parcel? Not my sunlight coming down on me, but what about when the sun's over there and I'm getting my light from over there and that light is traveling across that guy's piece of property? Well, that's sort of like an easement. That's sort of like my right to have an easement over his property so that I get sunlight. It's an interesting concept, but it doesn't fly in Florida. And there's a great case in the text, and I commend it to you. It's on page 197, and I think it's something we all kind of relate to. And we can relate to a couple of things. I like quite a few things it's doing based on stuff we've talked about before. It is the Florida District Court of Appeal. We talked about that, the Intermediate Appellate Court in Florida. This one happens to be from the 3rd District in Miami. And this is the Fontainebleau Hotel versus the Eden Rock Hotel. Two fat cat Miami Beach hotels next to each other. And what happens when one of them builds tall and blocks the sunlight, and the swimming pool of the shorter one, and all its cabanas and rich people laying out there trying to get suntans, all of a sudden at 2 o'clock in the afternoon there's no more sun coming in because the tall guy blocked my sunlight. And do I, as the shorter hotel, have an easement over that property, the taller hotel, for his sunlight? And the court said no. As long as what he did was legal and what he did was under the building code, that's too bad. Now, this has been tried in Fort Lauderdale. I don't know if you all saw bumper stickers everywhere. Vote no on marina lofts. There was a project, huge boat barn project that was going to be built right off of Cordova Road. It was going to be 14-story tall boat barn, you know, with forklifting boats up into a boat barn. It was going to totally block all day long the sunlight to a small condominium next door. Their pool was never going to be in the water. Never to be in the sunlight. And they tried to fight it based on that. And the courts have said, no, you have no right to an easement for sunlight over anybody's property as long as that person is building in accordance with the building code. But theoretically, there's an easement for sunlight. It just ain't going to carry in Florida. And then there's the same concept for air. What if he blocks my air? What if he blocks my breeze? You can get into all that stuff, and the answer in Florida still is no to all of it. All right, there's a section at the end here that talks about how do you terminate easements. This is a real no-brainer. You terminate easements by both of you signing a document that says, we terminate. That'll do it. This guy signs and records a document that says, I hereby terminate my easement. Now, if they build a road back here, that would be a nice thing to do. This guy would really be grateful if you would sign a document and terminate your easement across his property and free up him from the obligation of that, because you don't need it anymore anyway. Very simply, of course, you can terminate an easement by a release, and that's called a release. This guy would sign a release, releasing the easement. The other common way of killing an easement, terminating an easement, is both parcels are owned by the same guy. That'll kill it. Let's say this guy sold it to him, this guy sold it to him, and these two guys sold to each other, and we have one owner of both all of a sudden. The point is, if the dominant estate and the servient estate are owned by the same person, that's called merger. The two estates are merged into each other, and that extinguishes an easement. That's the second most common way to kill an easement. It goes on to 2 or 3 others that I think are really bizarre and they're not going to happen. I suggest you ignore them and you're not responsible for them. The one other concept I think to be considering as important is eminent domain. Eminent domain, of course, is when the government takes a piece of property. And when the government takes a piece of property, here's what you need to realize. The government terminates easements, period. The king can do no wrong, they can do whatever the hell they want to. If they take this piece of property, they can terminate this easement. Now, they may have to pay this guy for it. The question whether it's compensable. It may have rendered his property worthless, in which case they may have to buy the whole damn thing.
It might constitute a
But
taking.
the point is, they can take it. And that's a way easements can be killed, is by the government. Then the question becomes, is it compensable? And if it's compensable, how much? And that's why we have juries in condemnation cases. But the government has the right to terminate easements. And that's all I got to say on easements, on termination of easements. There's another section which we touched on a minute ago that I don't understand at all and I've never heard. And I suggest you don't need to learn it. I can't even pronounce this, profit apprendre. This is all about coming onto somebody's property to take crops or to remove topsoil. Never heard of it. And I've represented some farmers and I've still never heard of it. The last concept, and then we're finished with the chapter, is a license. A license is again a right to use somebody else's property. It's very much like an easement in gross, and frankly, there are a lot of them that I can't tell you which are which. Except that it may say, this is a license, or this is an easement. But other than that, from a use concept, sometimes it's very hard to tell because there is no dominant parcel that it's in favor of. But of course there's a servient parcel because the license is a license to do something on somebody's property. A couple of good examples in the book. A theater ticket. Your right to use the theater for 2 hours. A parking lot ticket, that's a license. And it usually says right on it, this is a license. It's the right to use somebody else's property for a limited period of time. And that's what an easement is. An easement, though, is for a longer period of time. Usually a license is for the shorter period of time. The big difference is, unless it says otherwise, a license can be terminated at any time by the party who issued the license. An easement we talked about is irrevocable. An easement is forever unless you do something to terminate it. A license, just plain old, the person that gave the license can revoke it at any time. And that's it. It's much less formal, it's much less dignified. If you wanted to give somebody the right to use your south 10 feet, and you wanted to have the right to cancel at any time, you give them a license. You don't give them. Okay. We're obviously very short on time, and I'm going to look at this lease with you for 2 seconds and tell you what's going on, but not page by page, and then we're going to go. The lease that I sent you is the standard form of lease for a condominium or a co-op apartment. It's only intended to last less than 1 year because of sales tax. This is the form put out by the Florida Association of Realtors, furnished to us by Town Real Estate again. It's pretty damn obvious what's going on here, and you fill in the blanks, and you see where you put in the premises and the parties and the term and the rent, and this is all real obvious on page 1. I want to show you on the bottom of page 2, paragraph 8, Roman 8, VII, use of premises. As we talked about, you limit what the premises can be used for. Residential purposes. On the middle of page 3, this is excellent. This is maintenance. We talked about who maintains the property in a landlord-tenant situation. Right on down here, it talks about, landlord has to comply with the building codes, but then it goes through this whole list of lawn, heat, air conditioning, furniture, appliances. Who's going to fix them, landlord or tenant? This is great. It spells it out. Don't have to fight over it. We've got an agreement now that says so. Near the bottom of the next page, two paragraphs, paragraphs 15 and 16, Roman 15 and 16. Default and remedies. In 15 default, it says, see the attached part 2 of chapter 83 of the Florida statutes that we talked about. That's the Florida Residential Landlord Tenant Act. It is attached. This is where it gets incorporated by reference into this lease. And everything in that act is now brought forward into this lease. And this is all about all the rules of what landlord and tenant can do to each other in the event of default.
I'm sorry, page?
I'm sorry?
8? What page? Number?
What paragraph? That was paragraph number 15. 15 in the middle of page 4, Roman 15, 2/3 of the way down. And the next one is important too, assignment and subleasing we talked about. Unless his box is checked, and landlord's not going to check that, I assure you. Tenant may not assign or sublease all or any part of the premises without obtaining the consent, the written approval, and the consent. So it's normally prohibited. Every lease says it's prohibited. Apparently you can check a box and say it's not prohibited, but I can't imagine why any landlord would want to do that. Next paragraph is an exculpatory paragraph. Here's where a landlord says, hey, I'm not liable if anybody gets hurt. And we have court public policy, and we have the chapter coming up that says, never mind, you are liable. And the exculpatory clauses don't work. And at the top of the last, what looks like the last page at the top of page 5, this is all about this lease has to be approved by the condominium association. And it's void if it's not approved by the condominium association. And it doesn't even take effect if it's not approved. And it goes on to say who pays the fee, who goes to the interview, who fills out the application, all that crud. But the point is, this acknowledges the association's got to approve it or there is no lease. And this looks like there's signatures on this page, but they're not. That's about lead paint. The signatures take place in the middle of page 6. And that's basically the end of the lease, except that the lease says, skipping 2 pages to 8, the lease says the entire Florida Residential Landlord and Tenant Act, which appears for the next 10 pages here, is incorporated by reference. So all the stuff that's in here applies to this lease. And let me show you just a couple of highlights. This applies only to the rental of a dwelling unit. That's it. And it's going to define a dwelling unit as a home or residence or a sleeping place of 1 or 2 or more persons as a household unit. But it's going to exclude dormitories and hospitals and prisons. It's not what we're talking about. Interestingly, it excludes the occupancy by the holder of a proprietary lease in a condominium apartment, because that's a different animal. That guy's an owner. And it also excludes the owner of a condo unit, but of course that makes no sense because it's not a lease anyway. The law goes on to say what unconscionable conduct is, what prohibited provisions are in rental agreements. Talks all about escrowing security deposits. If you earn interest, you got to pay the 3/4 of the interest to the tenant. Talks all about when the tenant moves out, what happens to the security deposit. Landlord has to make a claim within 30 days if he's going to keep some. Otherwise, the tenant gets it back. If tenant doesn't like the claim, he's got 15 days to object. Otherwise, the landlord gets to keep it. Interesting. It says that some violations of this act are punishable under criminal law as a criminal offense. Some things that landlord can do under here might be subjecting him to criminal prosecution by the state's attorney, in addition to, as we know, getting sued for damages and attorney's fees. The famous 3-day notices, that's where this comes from. The last 2 pages are all about litigation and what happens in a lawsuit. There's a paragraph about retaliatory conduct. You can't retaliate against your tenant because he really pissed you off. You can't increase his rent. You can't withhold services from him. You can't do anything to a tenant because he called the health inspector people to come look at the property. You may not retaliate against a tenant, and then there's certain prohibited practices, and these are the ones where you can run into criminal prosecution. Some of these are the biggies that people do in self-help that can get them in big trouble. You may not terminate a tenant's utilities because he's not paying his rent. You can't have his electricity turned off, even if you meter the electricity and even if you pay the electricity. You can't have his water turned off. You can't change his locks. And one that was real famous in the old days is you can't remove his doors. In the old days around Fort Lauderdale, when people weren't paying the rent, when landlord just went by and took your door off. That was it. He took the door home with him. You wanted your front door back, you came and paid him the rent, and he'll put your front door back. Otherwise, you're wide open. That's a prohibited practice. And has been for quite a few years. That's the drift of this. We're done. Let me give you an assignment for next week. And we're out of here. Chapters 10 and 11 that we skipped last time. Real estate contracts. And I'm going to send you a real estate contract. We're going to cover those two chapters. We're going to cover chapters 12 and 13 that we didn't get to today. So we have 10 and 11 to read, 12 and 13 that of course you've already read. We're going to cover those now. You're going to skip chapter 14 forever. We're never going to do it. Don't read it. It's about escrow closings the way they do them in California. We don't do that. Doesn't mean we don't have little escrow type deals, but we don't do escrow closings like they do, so ignore the chapter. And chapter 15. And stop there. I was going to assign 16 and 17, but we're never going to get there.
Let's do it.
Can't do it. And we're going to have a midterm next time.
How far is the midterm gonna cover for you?
It's going to cover everything we've covered so far, and whatever we talk about that morning before we have the test.
Will it go past 12 and 13, like will it cover 10 and 11?
Well, it'll cover 12 and 13 if we cover 12 and 13 before the test.
Let's do it.
You were theoretically to have read that this week already. So
Yeah,
I know you've already read it. It may or may not be on there.
No, I'm talking about 10 and 11 now. Will that be on the exam?
Oh, will it cover 10 and 11? It will cover 10 and 11 if we happen to talk about them before the test.
And how many questions?
That's all I can tell you. Right now, I haven't written the midterm. I don't know what's going to be on there. It's going to be everything we've already covered and some stuff that I'm positive that we'll get through before the test.
Professor.
This is it.